Lots of people ask if there is any slam dunk defense to the charge of speeding. And there is one excellent defense, which I'll come on to in a moment, but it comes along with its own warnings and dangers, which I will also explain in this video. But before I do that, the usual caveat, the best thing in all situations is just simply don't speed. You should stick to the speed limit, not just because you can get caught for speeding and get points and fine, but it's obviously a lot safer for yourself and everybody else on the road. But before we get to the main defense for speeding, let's talk about some of the other situations. So lots of people believe they can go to court and just hope that the police officer doesn't turn up, as some TikTok videos in the past have suggested, which I find ridiculous. Others believe that you can go and routinely question and challenge the calibration of the machinery, the cameras, or whatever else is being used to capture you speeding. In some situations, and one genuine area you might question, is the speed limit itself, because the signs have to be clear and visible on that road. And just like any other offence, the onus is always on the prosecution to prove that you were speeding at the requisite time and place, contravening that speed limit. And that brings us to one area which could well be an absolute slam dunk defense, which comes along with a very stark warning. Now, the only absolute slam dunk defense to a speeding charge is that it wasn't you that was driving. Now, as I said, the prosecution always have to prove that you were committing the offence, and that includes speeding. The dangers that come along with this, because a lot of people believe they can get away with this, is either not responding to the police when they send out a Section 172 notice requiring you to identify the driver of the vehicle at the requisite time and place, or that they can nominate somebody else. Now, just backing up a step, like I said, it is an absolute slam dunk defense to a speeding charge, and any other kind of driving offence for that matter, if you were not the person driving. However, as I said, that leads lots of people into the very dangerous territory of naming someone else or just ignoring the request to identify the driver. Dealing with those in turn, if you fail to respond to the 172 notice requiring you to identify the driver at the requisite time, and even if you go back and say, well, I don't know who was driving, they could still attempt to prosecute you as the registered keeper of the vehicle if you cannot then show that you've taken all reasonable diligence to find out who it was that was driving at the time. And courts are not very likely to accept this as an excuse. It's not impossible, but they're not likely to accept it. Simply because if you're the registered keeper of the vehicle, you're expected to know who's driving it and you're expected to be in charge and responsible for that vehicle. However, let's get into even more difficult and dangerous situations where somebody will name somebody else as the driver, and this typically happens when someone's got 6 or 9 points and then another 3 or 6 points on top of that is going to top them up to 12 points, which means an obligatory ban for 6 months. Now, what people very often do, shockingly often I might add in this situation, is name somebody else as the driver at that moment in time. Now, without doubt, this is perverting the course of justice, and we've seen many clients who've been prosecuted not just for the original speeding offence, but now for perverting the course of justice, so they see themselves in the Crown Court. Because if they've named somebody else as driving, and this could amount to both the person naming somebody else and the person who, if they agree to be named as that person who was driving, they are both perverting the course of justice. So whilst, as I said at the outset, it is an absolute slam dunk defense to a speeding charge or any other kind of driving charge, if you were not the person driving, what that leads to is people falling for this situation where you can be prosecuted for perverting the course of justice. So quite obviously, you should not be naming somebody else if it really was you that was driving. The only thing you can do in those situations is check whether the signs were clear at the time and whether the machine was calibrated. But these are all kind of technical reasons that may or may not go in your favour. And more often than not always, but more often than not, you're probably better off availing yourself of the fixed penalty or driver awareness course that you may be offered instead of a full prosecution. Now, of course, this is why you should always seek formal legal advice, because depending on your situation and all of the other factors thrown in there, how many points you've got, how long you've been driving for, because remember, new drivers can lose their license relatively easily and be required to take their test again. One of the main reasons it's usually better to accept the fixed penalty is if it really was you that was driving and you really were speeding or whatever it was you were accused of, and the signs were clear and the machines are likely calibrated and all of these kind of things. If you do go to court, it is likely to be a more severe penalty and costs and a fine and so on if you challenge it in court, because ultimately you've taken everybody's time up for something if ultimately you were guilty of that offence. But at the same time, if it genuinely wasn't you that was driving, then of course you should not be admitting to something that you didn't do. But in that situation, the registered keeper of the vehicle is going to receive a 172 notice, unless of course you were stopped at the side of the road and just mixed you up with somebody else. And the keeper of the vehicle has got to nominate and name who was the person driving. But as I say, if it genuinely wasn't you, then of course you should not be admitting to it. And that, of course, is the ultimate slam dunk defense. But the best advice, of course, is just don't speed in the first place. If you do get into the position where you end up in court and you are guilty, then you need good representation to mitigate your circumstances, to, if you are in the position of receiving a ban, to hopefully avoid that ban. But then it comes down to arguments over exceptional hardship, which means exceptional hardship, not just this is going to be inconvenient and costly to me, because that's sort of the point of a punishment. But anyway, those are my thoughts on what is the ultimate slam dunk defense to a speeding charge and the caveats and warnings that come along with it. Let me know in the comments below, have you ever successfully challenged the machinery calibration or the signs on the road and all of these kind of things? Because every situation is very slightly different. Let me know in the comments. Make sure you like this video and subscribe, and as always, thank you for watching.